all digesting this at this point in time, and it's something I'm going to talk with them too, because I think their feelings should play a role. So it's it's a process, and I'm not going to rush into it, and we'll go from there.
Can you share what some of the issues were that
just like just like we argued, just like the argument was, was was it the moment of the shot was fired? Was that what you're supposed to look at, or is it looking at the totality of the circumstances more? I was arguing, was the taser a dangerous weapon or not a dangerous weapon? It's basically what you saw in the trial and what the two sides focused on respectively. That's essentially what they were focusing on, which I appreciate. I mean, they definitely knew what the issues were, and it sounds like they had a very thorough debate on those, and they couldn't reach a decision, which is not uncommon. So I'm not criticizing them at all. I've never had a jury take that many notes and ask the amount of questions, and quite frankly, very good questions. So they were clearly engaged, clearly dedicated, and I appreciate what their work they did.
The jury foreperson came out and she looked really upset.
She was not. She talked about this. She's like, I know she just slipped and hit her chin. So.
And the FOP Lodge, State Lodge in Michigan, put out a press release just a little while ago, basically saying that public pressure is what led you to file these charges.
No public pressure. Yeah, that's if I had public pressure, just stuck my thumb up in the air and went with that. That had nothing to do with it. I base every decision based on the facts and based on what I think I can prove. This is not, I don't bow to public pressure, because there's a lot of cases I wouldn't issue or would issue based on what the public wants. I don't do that. So it had nothing to do with public pressure.
Given the results of this, do you have any second thoughts about bringing this?
No. No, I don't. No, if I didn't believe in the case, I shouldn't have been trying it. It's a difficult case. This is not an easy case. I've been involved in a number of officer involved incidents where I've cleared them, and if I clear them, that's because I believe it shouldn't go forward. This is one I felt, given all the facts and circumstances, that deserved to go forward. And so it's not a regret that we got a hung jury, and I'm not surprised at a hung jury. This was a difficult case, and you've seen the split in the community. You've seen the jury was, there's issues there. So that doesn't change, because, if you just try you charge a case to win it, you shouldn't be doing this job, because that's not your job. Sometimes they're going to be tough, difficult cases. This is a difficult one. It's difficult for the community. And so, but I still stand by the decision and charge.
Can you talk about what this has done to your relationship between your office and the Grand Rapids Police Department?
I've said this before. This has been pending for 3 years, and I'm preparing for a trial in 2 weeks with Grand Rapids Police Department. They're professional. We're professional. Clearly, there's people over there that don't agree with this decision, and I respect them. There are some people I probably respect. Nobody's confronted me. I think we still have a relationship. It's a working relationship, and I think it's we agree to disagree, but we still understand our roles and understand what we have to do for the community and protect the citizens. And we disagree on a case, but I think there's plenty of cases that we still work together on and work together very effectively.
The lesser included offense of voluntary manslaughter, was that something requested by you? And if so, when was that requested?
It's a necessary lesser included of a second-degree murder. So that's common for any, I've never had a murder case where it didn't get included unless the facts didn't show it. And I think clearly with the facts here. So yeah, we did request it, but that's just the normal, because it's a necessary lesser included offense.
Can you say whether they had dismissed the second-degree murder and were looking for
I don't know. That's not, we never got into that deep. So I really don't know how much what they were focusing on, in terms of.
You rely on the possession of the taser question. You put up experts who, in their testimony, said he never had full possession. The defense showed their version of the video where you see it in his hand. How much did that affect the case? Did that affect jurors, and it does affect the way you present the case going forward?
Oh, it definitely affected jurors, because they were debating on that. I mean, that was one of the things they were looking at, is the taser. What was he intending to do with it? What was it in his possession? So I think that was a key issue that both sides focused on, and they definitely looked at it. I can't get into their deliberations on how much it felt, but if I make the decision to retry it, that's something we'll take a look at and look, get the transcripts and go over it. And is there something we could have done differently? Is there what every time you have a case, it's the same case, but you're probably not going to do it the exact same way, and things are going to come out differently. So, it is part of the case, and it's an issue, but we'll see what happens.
So when speaking to the jury, can you talk about the emotions in that room when you're speaking with them?
Yeah, to be honest, I think they were, there are emotions, but I've been in hung jury where you can tell, oh my gosh, I think these people are going to kill each other. And this was not that. I didn't get that feel. There's, they disagreed. There's, definitely some tension, but they got along and they seemed to be, really trying to make an effort. So I didn't get the feel that it was like, a knockdown, drag out or anything like that. They, you brought from citizens of Kent County. They did the best they could. They had differences of opinion, but I think they were, talking about it, and it wasn't, hostile, at least the sense I got when I was talking with them.
Do you think, the first time the jury came back and the rule first up, they've been sent back in, this time she declared a mistrial? Do you think, had they been sent back again, they could have eventually reached a verdict?
No. This is, the note came back saying, basically, I don't think she read the whole note, but the note was, hey, I think one of the instructions is don't, give up your deeply held personal beliefs to just reach your verdict. And that was phrased in the note, essentially saying, hey, if you want us to debate more, somebody's going to have to do that. And so that's the time. And Judge Mims made a correct decision saying, yep, you've come as far as you can. So I don't think would have done anything more.
Did you receive an indication that the needle moved at all from Tuesday when they were still?
They gave us an idea, and there was movement. Yeah, definitely. It wasn't, they've been sitting in the same position for 3 days. So they definitely exchanged ideas, and there was changes.
Were you surprised by this outcome?
No, like I said, there's you look at across the country. I mean, I think I just found out the Memphis, that Memphis case went through, and that was a hung jury before. There was one in Detroit, a state trooper that was a hung jury. These types of cases bring divisions, and people have strong opinions, and so I'm not surprised. I always thought this is a definite possibility that we're not going to get a verdict, and that's what happened.
So if you retry this, I mean, did you change your strategy somehow?
Well, I'm not going to tell you that now. So, I mean, I don't know what I'm going to do. I don't know what I'm going to do now. So I've not even thought about what I'm going to do if I do decide to make the decision to retry it. So yeah.
Should the case be tried again? What was the difficulty in finding a jury pool that's not tainted?
Yeah, which I think the surprising thing is, I mean, we had an pretty extensive questionnaire that it's kind of, you guys are all here, and then how many people said, oh, we don't watch the news to some extent. And that's kind of surprising. But, I thought we went faster in terms of picking a jury. We left a week because we thought, there'd be so many people that saw it and had an opinion and weren't going to be fair. And for the most part, there's a lot of people that didn't see it and didn't have an impact. This is maybe a little bit fresher, obviously, since this was 3 years ago versus, whenever if there is another trial, when that's going to be. But I think it's always amazing when you get into I've done a number of high profile cases, how many people are like, oh, don't hear anything about it, don't know anything about it. I mean, there's a number of people that never heard about this case. So I'm not as concerned, but probably have to go the same process.
What's the timeline you're thinking of on the decision?
I mean, I'm not going to let this drag out. I mean, I'm going to be considerate of the community. I mean, this is a big decision, but I'm not going to rush through it. But I'm not going to sit here and it's not going to be June. I don't have a specific timeline, but I hope to know relatively quickly.
Seeing the outcome, how do you think you guys did on selecting a jury?
Like I said, they're very dedicated. I mean, they're a very dedicated group. You never know. Every time you go in, you'd like to think, they're going to come to a verdict and everything. But this happens. This is a difficult case, and this was a very engaged jury. They were, like I said, I've never seen this many notes being taken. I've never seen that many questions. I've never seen that many good questions. I mean, sometimes you get really dumb questions, and this, for the most part, this jury was not that. So yeah, I think this was a good jury, and they did the best they could and didn't come to a conclusion. But that doesn't reflect on this was a bad jury because of that.
Do you think it was a factor that one of the jurors has a partner as a police officer?
Yeah, I don't know. Maybe everybody that we asked the questionnaires, thought they could, you can't just exclude people because they have, a partner or know somebody that's a police officer. So, at the time we made the decision, it seemed to be fair and impartial. They all represented that. So, okay. Take one or two more because.
You didn't use all of your challenges during jury selection. What led to the contentment between both you and the defense? You also challenged.
Well, you always get, they had more than me. So at the time when they had 4 left, I had 2 left. So I was kind of putting myself in a position. So at that point in time, I was fairly satisfied with the jury, and I didn't want to, put myself in a situation where all of a sudden I got none and they still could strike, and then I'm stuck with somebody who I really don't like. So that was just, it was a strategic move based on I thought I liked the jury. you don't want to get too cute, just use the preemptories, and then you're stuck. So
If there is a retrial, is there any talk about the change of venue?
I would doubt it. I don't see why, like I just said, I don't see why there would be. It's, we've had enough people that didn't hear about the case, or, when we pick this one, I don't think it's going to be an issue.
Could you talk more about the reaction of the Leolia parents? How the emotions after this, you met with them?
I met with it. They're disappointed. This has been a long truck for them. I mean, this has gone on, longer than most cases, as you're familiar with. This is, 3 years afterwards, and here we just got done with a trial where a lot of times we've, maybe in the appeals process or it's over. So this is, I cannot, I've talked with them. They're amazingly patient. They're amazingly, understanding. But I think they're frustrated, obviously. So, okay. Thank you.
Good morning, everyone who's got questions.
Did you speak to the jury?
I spoke to some of the jurors.
What's the impression you got?
I think that they were deadlocked early, and it wasn't really something that there was a lot of back and forth. I do think they deliberated and thought about all the issues. It sounds like they listened closely. I thought it was a very good jury of people that were put in a very difficult situation. And so, they did their job. And sometimes this happens where you can't get 12 people off the street to agree as to a very important decision. So I thanked them for all the work they did. Some of them were willing to talk to us. And so my sense is that they worked very hard to come to a conclusion, and sometimes you just can't.
Can you talk about the reaction of Christopher Shore?
He's been living with this for 3 years. He obviously wanted some resolution. I think he felt that the jury took the time to deliberate. He appreciates that. He obviously wanted it to be done, but it's a hung jury. So I haven't had much chance, obviously, to talk to him yet because I've been talking to the jurors. So, he'll probably have to reflect on it, as we all will, and as will Mr. Becker, on how we proceed next.
What do you think about the possibility of a retrial? What do you think should happen?
I do not think this case should be retried. I don't think it should have been charged in the first place. I think that it was clear, based on the evidence, that there wasn't enough to establish a charge in this case. I think there was a lot of evidence at trial that was irrelevant and that shouldn't come in. And so if there is going to be another trial, we're going to likely seek rulings from appellate courts as to what evidence is put before the jury. In particular, I do not believe that this theory that was sponsored by Professor Stoughton, how an officer can put himself in jeopardy by following what he believes to be poor policies of GRPD, where he loses the right to defend himself should he later be put in a position where someone is about to use, he's an imminent threat of bodily harm or death. I think that's absolutely wrong. I think the jury was confused by the fact that the prosecutor was saying that he cannot defend himself because he screwed up on whether or not he should chase him. I think that had effect on the outcome and the fact that they couldn't reach a unanimous verdict. And so if there is going to be another trial, we're going to be asking the Court of Appeals to decide whether officer created jeopardy is something that should apply in a criminal case, and whether officers, if they make any negligent act early on, they can no longer defend themselves if someone turns on them with a dangerous weapon.
Were there a number of appealable issues that you saw in this trial?
Yes.
Can you talk about those, other than what you just spoke of?
Substantively, that's the main issue. And, to those that are following legal opinions, there was a U.S. Supreme Court case just in the last 6 months called Barnes v. Felix, where this exact issue was argued extensively. I think that, this officer created jeopardy is incredibly dangerous, not only for police officers who are asked to put themselves in dangerous positions, but for the community. Because what's going to happen if you instruct officers that they cannot arrest somebody, and it's up to the person being arrested to decide whether they're not going to be arrested, you're going to see a lot of officers who are going to hold back and be instructed that if later on this person has a gun or gets a dangerous weapon and uses it on me, I can no longer defend myself because I've screwed something up early on. So that's the primary appeal issue. We, as you know, Mr. Coker, we briefed that extensively before the trial. We tried to exclude it all for the trial, but yet it became the central issue. It's clear to me, and if you listen to the prosecutor's closing statement, that he talked about the chase and whether or not that was reasonable, when the issue should have been whether at the moment of the threat, whether Christopher Scher was in fear of great bodily harm or death, and whether he acted as a reasonable officer would in that situation. So that's,
Sorry.
go ahead, Duncan, right?
Sam.
Sam, sorry.
The decision for Scher to testify, how and when was that made?
We anticipated he would testify, and as we saw the proofs come in, we felt that it was important for the jury to hear from him, because it's a case where what he was thinking, what he was feeling is important. And while there were plenty of experts on both sides to talk about whether it was reasonable, the only person that could say what was in his head is Chris. And it was a matter of, well, if something happens where he shouldn't testify, we won't have him testify. But the plan was he was going to testify unless something happened.
Did you not let play with the jury? Did you spoke to the jury about his testimony, what difference that made at all?
I think they considered it. I don't think anybody thought he was dishonest in his testimony. We didn't talk to a lot of the jurors, and I'm not going to get into specifics of what they're telling us, but I think it played a role, but wasn't the dispositive witness.
You can't tell us how close they were one way or the other. Was it 11-1 one way, another ways, half 50-50? Can you talk about that?
It was overwhelmingly in favor of acquittal, and there were holdouts on the other side.
How many holdouts?
I don't know for sure.
How long were you talking to the jury after this trial was acquitted?
I don't know what from the time of the mistrial until I came down here. I don't know how long that was.
During close, you had mentioned that you didn't have to put on a defense, but you did because of the importance of the case. Moving forward, should this be retried again, are there different approaches that you may take? I know you can't get too much into strategy, but were there things that you left out this time that maybe you think next time would be appropriate to bring in?
It's kind of speculative. I don't know. It would depend on what the trial looks like going forward. I mean, if we're arguing about whether or not he was negligent in chasing him, then I'm going to have to address that again. I just don't think that should have been ever put before the jury, and because it came down to whether or not GRPD's policy or no policy on foot pursuits had some sort of bearing on whether or not he can use deadly force to protect himself. And I think over half the trial was about irrelevant evidence. You had experts on both sides talking about how close you can stand to somebody when they deploy their taser. I don't know how that relates to a minute and a half later when Mr. Loya has exclusive control of the taser and is turning. It shouldn't matter. I was flummoxed by the fact that an expert can get on the stand and say, because you're too close, Mr. Loya grabbed the taser. That was a decision that was made by the individuals that were in that situation, and not because of some GRPD policy.
Matt, you asked for a mistrial on my count 3 times, maybe it was 2.5. Judge then said you put something in motion by rolling for eyes. What did you think of the judge in this case? And was this a fair trial? You keep asking for a mistrial. Was it ultimately fair? Did you do a good job?
We asked for a mistrial, and the primary reason was because there was all this evidence put before the jury that we did not think was relevant, and that was the focus of the prosecution's case. As far as the allegations of facial expressions, we obviously don't make those allegations unless we're certain that they're occurring. It was a crowded courtroom. It was our belief that the judge had been communicating with the jury. Why she might be biased, we never suggested one way or the other. We just thought that her demeanor at times suggested that she had feelings about something that coincided with the testimony.
So someone on your defense team actually saw her rolling her eyes, is that what you're saying?
Yes.
How many times? Did you talk, was it often, was it frequent, one time?
Throughout the trial, we thought there were facial expressions and didn't raise it. And then when Officer Schur testified, we believe that there were facial expressions that were communicating something to the jury, and that's why we filed the motion. Yes.
Sorry to interrupt you. When you said earlier that the jury was in favor of acquittal, do you mean acquittal on the second degree murder charge for voluntary manslaughter?
Both.
Okay. And you don't know the split of it?
The split goes back and forth. It just, it was communicated that it was, there was always a majority for acquittal on both. And I don't know whether or not, this is probably your next question, they all agreed to acquit on second degree murder or not. That wasn't communicated to us one way or the other. When I asked before the mistrial was declared, I was asking for the judge to ask the jury whether they could, if they had reached unanimity as to count one, which was murder in the second degree, and she declined. She's not required to do that under the rules, but if they had reached a verdict on murder 2, then jeopardy would have attached and there wouldn't have been a retrial.
Did you get a sense among the jurors that it mattered that 2 of them had relationships with police officers? One was dating a police officer, one had a grandfather who was shot in the leg. Did that matter at all?
That didn't come up. No one since, yeah. I mean, I thought that the jury did a great job of setting aside any biases or prejudices they might have one way or the other. A lot of us know police officers. It doesn't matter where you're on the political spectrum. And in my experience, most people respect police officers for the difficult job they have to do. But I don't think it weighed in their decision. And I didn't ask them, and nobody said anything.
You left a number of challenges in your pocket during jury selection. What made you feel like the jury that you had was the best one you could get?
It's always tough. I heard Mr. Becker's response. I felt it was a fair jury, and we were looking for people who would say that they're open-minded, that they hadn't really followed the case, that they didn't feel strongly one way or the other about police in general or other sort of important political issues. And I think we had that jury. You never know who's coming up next. And when you run out of that last peremptory, then you can't get rid of somebody if you get someone who isn't open-minded or for either side. So it's not unusual for me, at least as a trial attorney, to have a few peremptories left. I tend to believe that most people are going to be fair-minded, and talking to the jurors, they really were. They listened to all the evidence and they considered it over the course of days. So, what could have happened if I'd used more peremptories? I don't know.
So if this case gets tried again, would you ask for a change of venue?
That depends. If we don't think we can get a fair trial here, we would consider that.
If it was a majority for acquittal, do you think that should come into play when Prosecutor Becker is reconsidering retrying this? Is that something?
I think he should consider that. I mean, what better litmus test for whether or not something should be charged if whether or not he can prove it beyond a reasonable doubt. And I think as a former prosecutor myself, certainly you could say, oh, there's probable cause to charge, but the standard should be, do I think I can prove this beyond a reasonable doubt? And now we've gone through a test run, which frankly, the evidence I thought was in favor of the prosecution and the way it was let in. I think, I hope that Mr. Becker considers that partial judgment when deciding whether to move forward. And we don't think he should.
Do you take this as a victory? And how do you take this?
This isn't this is not winners and losers in this case. I mean, Christopher Scher never wanted to take a life. I guarantee it. He is the nicest man. And this was the most difficult thing he's ever had to deal with. That decision in that split second. And we cannot declare victory because there really is no winning here. A man died, and that is a very serious thing. Christopher Scher is happy that the jury didn't determine that he's criminally responsible for that death. But, you know, it's hard to say that we feel like this was a victory.
Has Christopher Scher said anything about his future plans now that this trial is?
I don't think he's had a chance to think about it. Obviously, there's a lot of things that could happen. I mean, he's working. He's got a lovely wife and family. You know, I think he's probably going to continue with the status quo. You know, and see how things unfold. But he's a pretty even-keeled person. You saw him testify. That is his personality. He doesn't like talking in public, but understood he had to. And going forward, I'm sure he's going to reflect. He'll probably pray on it and figure out whether he wants to change jobs or anything like that. But
Did Mr. Scher ever talk to you about how he felt about the crowd of supporters and protesters that would greet him every morning?
I didn't really have any conversations with it. I know the family, and I know Chris appreciated all the support for law enforcement in general. He recognized and respected the fact that everybody can have opinions and is willing to, you know, he was more than willing to listen to people who are against his position. So he's just not the type that's he's not a very political guy. And so he was more focused on the case itself. So, you know, and we wanted to focus the jury too on the actual issues and not the greater issue of policing in America and in Grand Rapids and specifically, because those are important issues. But what was at issue here was whether or not he could use deadly force in that situation.
Matt, at this point, the video that the public has seen for the last 3 years is maybe a little different than the view you provided in court with your forensic video analyst, specifically on Patrick's hands. You know, we've all been saying that there was a struggle over the taser. You showed that close-up view showing that Patrick had the taser, as Christopher said. Do you think it's important for the public to see that view, and do you think that changes, you know, outside of the court, how he's viewed and how his life is lived with that view in mind?
I think that what the trial can do, because it's a public proceeding and you can all see the evidence now, is it can address some of the misinformation that was provided to the media early on, especially about Mr. Leolia's background or what he was doing that day. I think it's great that people recognize now that it's clear that Mr. Leolia had it in his hand. Now, how he had it, I mean, I guess you could debate that. But yeah, I think it's important for the public to know. What was more important is to get it before the jury and let them decide, and hope that they didn't consider any prior misinformation that was out there.
Will you be at all in contact with Prosecutor Becker as he makes his decision whether or not to retry the case?
If he's willing to talk, yes. You know, I've known him for many years. Obviously, we have some input, and if he's willing to talk to us, we'll talk to him.
Can you talk about whether the jury, I mean, obviously, they watched the video, it's a gunshot to the back of the head, and how difficult, or whatever, to get around the optics, the gun to the back of the head.
I don't think it played any role in their deliberations, and the reason is because as the evidence came in, even the prosecution's experts acknowledged that the location of the deadly force is absolutely irrelevant. And this is one of the things where attorneys for the Leola family, I think, have spread information that is not legally relevant. Sure, optically it looks bad, but I don't think the jury even considered, because Seth Stoughton and Mr. Bloomfield, experts for the prosecution, agree that it's the decision to use deadly force and whether that is reasonable, not where you shoot somebody. And it's terrible that it's the back of the head optically. I get that, but it's legally irrelevant. And I don't think the jury even considered it. I didn't hear one person even bring it up.
Matt, you wanted to bring up Leoya's criminal history and past leading up to this incident. Is that something that you think would be important to bring to a jury in a future potential new trial?
And the issue was whether or not what was in Christopher Scher's head, what was in his knowledge. And the reason the defense was going to bring that up is because in large part, the prosecution was going to bring it up first. And so we wanted the opportunity to rebut that. And we also wanted to explain why he was fleeing and why he was fighting so hard. I think that is from a jury's perspective. I don't know that it matters that much. It really matters what Officer Scher knew. And so, if we have to do this again, whether we're going to have those similar rulings, I don't know. I was also troubled by the fact that the prosecution's experts focused on the intent of Mr. Leoya without us having the opportunity to explain why we think his intent might have been different what they were saying. They consistently suggested and put evidence that he intended to look at the noise in his car, where we were going to argue that based on evidence that we had and wanted to put in front of the jury, his intent wasn't to go look at as to whether or not there was something wrong with his car. His intent was to immediately run away, but the officer was on top of him. So those sort of things didn't come in. I don't know in the future what we'll try to put in or not. A lot of it's going to depend on what the prosecution's case is.
Should Mr. Becker decide to retry this case, do you think the time that has passed since April 2022 plays an impact, in just the term of maybe potential jury selection or the, I don't want to say freshness, but like the kind of the overall time period that has passed since the initial incident?
I think that's a good question, and that the prosecutor always considers what the community standards are at that time. I mean, things change over time with regard to whether police should act in a certain way. That might come into his decision. That ultimately, that's Mr. Becker's decision. Obviously, our opinion on whether he should charge it, whether it was 2022 or 2025. We don't think he should. But these are important questions too. I just hope that if we have another trial, it is not about the greater, maybe more important picture or a question of whether or not GRPD should chase somebody, whether or not their policies are consistent with community standards. A criminal trial for murder should never be about broader, very important questions about policy. And that's why we think this case shouldn't have been tried. Because that's not what this case is about, but it became that. And so if we're going to do that again, I think it'll be error once again.
The FOP Lodge put out a statement just a little while ago saying that the fact that charges were brought at all is because of public pressure. Can you talk about what's your response to that?
It's up to Mr. Becker to decide what he wants to do. He's the one that has to make these decisions. They're tough decisions. Whether he succumbed to pressure, you're going to have to ask Mr. Becker. I have my opinion as a former prosecutor whether it should have been charged in the first place. I don't think it should. We offered to talk to Mr. Becker before it was charged. There were some limited discussions, but we didn't have much input on that. So you'd have to ask Mr. Becker.
What's your confidence level given the time that's passed and what we saw today happen, that if this were retried, whether or not there would be an acquittal as opposed to yet another hung jury or even a guilty verdict?
I thought we were going to win the first time around. So obviously, I feel even stronger that we would win should we have to retry it. Okay, thank you.
All right,